So Barnaby has come all the way from London to help us with his insights on Shell. He's going to tell about a case that he's already been working on for how many years, Barnaby?
5 or 6 at this point, yes. Thank you first of all for coming and for having me here. We've talked a lot about Shell from a macro perspective and the climate perspective, and very helpfully Jeanette set up some of their history in Nigeria, where Shell has been, if not the biggest investor, and it must be very close, going on 50 or 60 years, where Nigeria has been going through a massive oil boom. But very few of those benefits have passed on to the average Nigerian citizen. 80% of Nigerians still live on less than $2 a day, for example. And so I'm going to take a slightly different approach. I'm going to tell you about one story, one specific case that we've been looking at for 5 or 6 years and investigating, and has led to a fairly extraordinary potential for accountability for a company like Shell. Before I get into that, first I should say Global Witness is an international NGO based in London and Washington DC, and we try to break the link between natural resources and human rights abuses, environmental abuses, and corruption that seem to so often accompany the exploitation of those natural resources. So the story I'm going to tell starts with this man. In 1998, this man, whose name is Dan Etete, was the Nigerian Minister of Oil during the reign of Sani Abacha, the Nigerian dictator. And in 1998, Dan Etete, in his ministerial role, allocated a whole series of oil licenses to companies, most of whom had never been heard of before, and whose ownership was very uncertain and over time has become increasingly suspicious. One of those oil blocks, called OPL 245, Oil Prospecting License number 245, which is actually a square of several thousand kilometres worth of water containing possible oil deposits off the coast of Nigeria, was allocated to a company called Malibu Oil and Gas. Malibu had been set up just 5 days earlier, and among its owners, as we now know, were Dan Etete himself and Sani Abacha's son. At the time, the upfront price, the signature bonus for that oil block, was just $20 million. But even in office, they couldn't afford this. And even if they could, a Minister of Oil and a couple of cronies with no real office address even, let alone oil rigs, geoscientists, all the rest, can't do much with an oil license. And so in 1998 and onwards, they set out to find partners, people they could sell a stake in the block to and who would help them develop these potential deposits of oil. And the company they found, unsurprisingly given that it's Nigeria, was Shell. In 2000, Shell agreed to pay $150 million in exchange for 40% of this license. However, that deal didn't go through at the time. Something had happened. Sani Abacha, the dictator of Nigeria, died in 1998 very suddenly, and Dan Etete and his friends' hold on this license was weakening. And in 2001, the new Nigerian government, then of President Obasanjo, cancelled the license. And in cancelling the license, he said Etete and Abacha had abused their positions in the past while in office to award themselves the OPL 245 at a ridiculously low price. It's fairly straightforward. Etete had concealed his ownership of the stake, but very flimsily behind a false name. Shell, having nearly got their hands on this potentially very promising oil license, proceeded to sue, but before that went anywhere, the Nigerian government invited them to bid for the block themselves. And in 2003, after a very limited bidding process, Shell was awarded 100% of the block to themselves at the much more significant upfront price of $210 million. Bigger, still, not reflection of the true value of the price of an oil block, but you shouldn't pay for these things up front anyway, so that's fine. For several years, Shell drills on the block and discovers very promising signs of very large oil deposits. They really see it as one of the gems of offshore Nigeria. And of course, offshore in Nigeria does not carry some of the same issues that onshore does. Drilling in the Niger Delta does have issues of sabotage, does have issues of resistance by local communities, and the costs that go with all those things, and the need for clean-up and legal cases and all the other hassle. Offshore does not have that, and Shell has been steadily moving offshore in Nigeria. So Shell holds onto the block until 2006-2007, where legal cases brought by Dana Tete culminate in a settlement with the then Nigerian government. So the block changes hands once again, back into the hands of Dana Tete. The way in which that settlement happened is still very questionable. Dana Tete had lost his court cases, and the Nigerian Attorney General who did this settlement would later receive $10 million. But we're back in the same situation. Dana Tete and his cronies have a potentially very valuable oil asset, a stolen state asset, that they need to sell. They need to do something with because they can't do anything with themselves. And once again, they couldn't pay the price that they were supposed to have paid up front for this license. They were told they would have to pay the $210 million that Shell had agreed to pay. And of course, they couldn't come up with $20 million in 1998, and they certainly can't come up with $210 million in 2007. And it gets more complicated as well, because Tete, in 2007, was convicted of money laundering in the French courts. Originally, he was sentenced to a jail term that was reduced on appeal, and he owed a massive fine to the French legal system. And from 2007 onwards, Tete is trying to find a new owner, a new buyer for the block, someone who can develop it and will pay him the money that he owes to the Nigerian government, pay him the money that he owes to everyone else, including to the French court system. And at this point, pretty much everyone knows and is talking pretty publicly that Tete is the guy behind this mysterious company, Malibu Oil and Gas. They knew from fairly early on, but it's very much out in the open. And they approach a bunch of companies. He hires several middlemen to go out and find buyers. They talk to Chinese companies, Russian companies, and all the time they're still talking to Shell, who are suing in the arbitration courts to say this block has been taken off us. Can they come to a deal? And eventually they do come to a deal. In 2011, Shell and the Italian company Eni, who have already been mentioned, agree to pay a grand total of $1.3 billion for this block. Of that $1.3 billion, which they said was going to the Nigerian government, only the $210 million, the long overdue signature bonus, actually went to the Nigerian government. The other $1.1 billion is put into an account in the name of the Nigerian government at JP Morgan Bank in London, but is then transferred on to Malibu. The companies were aware of this, though they denied it. At the time, 2012, shortly afterwards, Shell stated that Shell was not aware that money was to be paid to Malibu. They said that inspection of Malibu's company records as part of the due diligence did not establish any connection between Dana Tete and Malibu. And Ben Van Beurden told me, actually, in 2015, "We have never been anything but transparent about this. There is no risk and nothing extraordinary about this transaction that should concern our shareholders. We believe the payment was made entirely in accordance with the law of Nigeria and international practice and was morally okay." I should say that very little was known about the history I was telling you before at the time. Shell and Eni didn't announce much about the deal in 2011 at all, and very little information is publicly available about pretty much anything that happens in the oil industry. But things went wrong in this case. The middlemen I mentioned that Tete had hired both sued. They said that they were owed commissions and these went unpaid. One sued for $200 million in the English High Court, another sued for $75 million in the US and UK courts. And in the process of those lawsuits, they put an enormous amount of information into the public domain about how negotiations had happened and what the deal actually looked like from the inside. Since then, we've continued to investigate and have found court documents, we've found company documents, we've talked to people involved in the deal, we've had leaks, and we've compiled a vast amount of information on this case. What we found contradicts what Shell said very conclusively. So, as early as 2000, Shell wrote an internal email, this was Shell executives saying this, quote, apparently there's no connection between Atete and Malibu, so we'll have to find out who's holding shares on his behalf. There was no illusion that there was anything other than Atete. And he put it very deliberately later in their 2010 due diligence that we had leaked. Whatever the formal ownership structure of Malibu, all of the sources to whom we have spoken are united in the opinion that Dan Atete is the owner of the company. They'd previously also told us and their shareholders at annual general meetings that they had no knowledge that Atete was the owner. But the knowledge didn't just end with the, knowing who was behind Malibu and that this open secret was in fact true, that Dan Atete, the former oil minister, a convicted money launderer, was their counterparty in this deal. The knowledge went to the top. So Peter Voser was the then Shell CEO at the time of the deal, and an email was forwarded to him which said, Atete can smell the money. If at nearly 70 years old he does turn his nose up at 1.2 billion, he is completely certifiable and we should then probably just hold out until nature takes its course with him. But I think he knows it's his for this taking. There's quite a few others of these, to be honest. After we started publishing material about this and one particular report last year called Shell New, Shell changed their line on this. After telling us for years that they didn't know that Malibu was really Dan Atete and where this money would go, they instead changed their line and said, over time it became clear to us that Atete was involved in Malibu and that the only way to resolve the impasse was through a negotiated settlement to engage with Atete and Malibu, whether we liked it or not. And added that Shell knew that the Nigerian government would compensate Malibu for its claim on the block. That much was actually very obvious from the documents, from the contracts that have come out around this deal and from what Shell was discussing. But they finally admitted it 6 years after the deal, after years of pressure and years of misleading the public. But their knowledge didn't end with just that this money, this $1 billion that they were paying, was going to a convicted money launderer. It went further than that. So this is an email from 2009 between several Shell staff members on the ground talking to other executives. And they're talking about the OPL 245 deal. And it starts with, spoke to Mrs. E this morning, which we think is Mrs. Atete. It's not quite clear. She says Atete claims he will only get 40 million of the 300 million we're offering. Rest goes in paying people off. At the time, I should say that they were talking about a $300 million payment. That's why the numbers are different. But the knowledge from 2009 is very clear that they understand that this money isn't staying with the guy who stole a state asset, the convicted money launderer, but that money is a way to pay other people off. Another email, this is from 2010, so in the run-up to the negotiations. Interestingly, it starts with no PKI, which I understand is Shell's encryption method. So this is what's in the unencrypted emails, which does make you wonder what might be in encrypted emails. And they're talking about a letter that Dan Atete had supposedly secured from Goodluck Jonathan, the Nigerian president at the time, supporting his claim that he was the owner of the license after the settlement and all the rest. And if you look at number 2, it says, this letter is clearly an attempt to deliver significant revenues to GLJ, Goodluck Jonathan, as part of any transaction. So Shell executives discussed amongst themselves that the deal was a route to pay Goodluck Jonathan himself. There are more of these. This is a briefing for Shell's then number 2 guy in the whole business, a guy called Malcolm Brinded, who was head of upstream at the time, ahead of a call he had with his opposite number at Eni. this is August 2010. In-country view is that the president is motivated to see 245 closed quickly, driven by the expectations about the proceeds that Malibu will receive and political contributions that will flow as a consequence. We published these emails and others last year and said that this shows Shell understood they were paying to a vast bribery scheme. We stand by that conclusion. The money that got paid has been traced by us and by law enforcement. The $1.1 billion that Shell and Eni paid into the Nigerian government flowed on to Malibu, which is the second level down. Some of it was frozen and stuck in places because of these lawsuits by middlemen. Of the rest, $800 million went into Malibu accounts in Nigeria, of which $520 million was turned into cash by someone who's accused of passing that money on to senior Nigerian officials, including the former president, the former oil minister, and the former attorney general. Other money was spent by Dan Atete on things like a luxury jet, on armoured cars, and indeed on paying off his French money laundering fine. So that's part of the story, that this $1.1 billion payment made by Shell and Eni funded what are alleged to be vast bribes to Nigerian lawmakers. On the other side, Shell and Eni, we've discovered, secured remarkably favourable terms to develop this oil. The value of an oil field is really in how much value is kept by the oil companies who develop the oil. In Nigeria, since the mid-90s, they shifted to a system called production sharing contracts, where an oil company or a consortium of oil companies are essentially contracted by the government to lift the oil, to drill the oil, and some of the oil is kept by the companies as their profits. The rest goes to the government through separate streams of royalties, taxes, and the sharing of production. The thing that gives a production sharing contract its name, the sharing of production, otherwise known as profit oil, the oil that's left after the costs have been taken into account. Shell and Eni had a contract after 2011 that said that was called a production sharing contract, and everyone assumed was like every other production sharing contract in Nigeria. But we realised we had access to Shell's contracts in this case, to their valuation of the field, their development plan, how much they thought it would cost to develop it, and of course the Nigerian legislation that will apply to this. And we brought in some really top-class oil experts from a company in Canada to evaluate what the cost to Nigeria would be from this deal. Because, as I say, the contract they got after 2011 is not a typical production sharing contract. Contrary to the name, Nigeria will receive no share of profit oil, no share of the production that comes from this oil block. And the consequence of that is very dramatic. The International Monetary Fund says that a mature oil-producing country should get somewhere between 65 and 85% of the profits from drilling for oil after costs are taken into account. Previous terms offshore in Nigeria were never thought to be fantastic for the government of Nigeria, but we looked at the previous contracts that came from Shell's original oil hold on a license in 2003, and the contract that Malibu should have had from 2007 onwards when they had the block returned to them. And they would have given Nigeria 60 or 65% of the profits from drilling for oil. Instead, the 2011 deal gives the Nigerian government just 41% of the projected revenue from this block over its lifetime. I should say this is a projection. You have to make assumptions. We had to assume that Shell's estimations and valuations of this block were largely correct and fill in a few holes, but we had an extraordinary amount of data in this case. And we've plugged in some numbers that we feel are very reasonable, like oil being $70 a barrel going forward. You have to pick a number. That's a relatively conservative number, and we've tried to take conservative measures. But what those estimates give you is a split of profit that's truly extraordinary and really incredibly poor for Nigeria. And to put that into absolute and real terms, compared to the previous terms, the 2005 terms that governed the bloc before the 2011 deal done by Shell and Eni, Nigerian government will lose nearly $6 billion at a $70 per barrel scenario, which, to put it in context, is twice Nigeria's combined health and education budgets. And that's in a country where 1 in 10 Nigerian children don't make it to see their 5th birthday. So while we're talking about corruption, this has real concrete impacts on Nigerians day-to-day who live with poverty, and deals like this could affect Nigeria going forward for decades, which is the lifetime of this project. Nigerian officials objected to the deal at the time. This is a letter that was sent just days before the final deal from the most senior civil servant in Nigeria's Department of Petroleum Resources. And he criticised it, saying that it is highly prejudicial to the interests of the federal government, and they could take other roads, essentially. So this was done over the objections of Nigerian civil servants at the time by Nigerian former ministers who are now accused of receiving enormous bribes. Now, the consequence of this is unusual. We don't believe that this is an isolated case. We know that the oil, gas and mining industries, the extractive industries, are thought to be the most corrupt in the world. And that's not my view, that's the OECD's view. But in this case, after our investigations, we filed criminal complaints with various jurisdictions. And at this building in Milan, one of the largest corporate corruption trial ever that we can find records of is happening as we speak. Shell, Eni, and some of their most senior current and former executives are standing trial on charges of international corruption over this case. For Shell, 4 former staff members and executives are standing trial, including Malcolm Brended, the former head of Upstream, Peter Robinson, the former head of Sub-Saharan Africa, and 2 former MI6 officers who Shell was employing on the ground in Nigeria. Alongside them from Eni's current and former CEOs top the list of their executives on trial. Alongside them are various middlemen, Dan Atete himself, and others. Charges are also laid in Nigeria against Shell's subsidiary, Eni, and several executives there. And there have been active investigations in other countries, most notably the Netherlands. So this is fairly extraordinary. We very rarely see a trial of corporations on the scale of Shell. Essentially, we've never seen this, is what I'm saying. And this provides a window into the way in which a company like Shell operates that we so rarely get. This deal, we have this unique window into, but we don't believe it's unique. It shows a way of dealing with a country like Nigeria that should be hugely concerning to the public and anyone who's in business with Shell, essentially. I should say as well that these weren't first-time offences. Both Eni and Shell had done what are called deferred prosecution agreements, essentially settlement agreements with US authorities just a year before they went out and did the OPL 245 deal in 2011, where both companies were accused of corrupt deals, coincidentally both in Nigeria. So this is a second offence for both of them, arguably, should they be convicted. Anyway, I will leave it there, and I'm very happy to take questions.
Thank you very much, Barnaby. This was an impressive insight into the world of oil. You created court cases in 6 countries. That's rather impressive, I would say. I want to propose that we leave the questions till after the next 2 speakers, because we have 2 people waiting in the US.
Okay.
And so I'd like to bring them in, and then we do the questions together, okay?
Sure.